The Chair will introduce our first panel, composed of two of our colleagues. The first is Honorable Michael Arcuri from the 24th District of New York, and the second gentleman I've already introduced in my opening comments when he was not here, the gentleman from Oklahoma, Mr. Cole, co-chair of the Native American Caucus from the 4th District of Oklahoma. Mike, Tom, we welcome you to the committee. We do have your prepared testimony. Will be made a part of the record as actually read, and you may proceed as you desire. Mike, you want to go first?
Yes, thank you, Mr. Chairman. Chairman Rahal, Ranking Member Hastings, distinguished members of the committee, thank you very much for giving me the opportunity to speak here today. The subject of today's hearing, Indian Land Trust, is a paramount issue in my district. I represent an area of central New York that I always say is blessed with not one land claim controversy, but two: the Oneida and Cayuga tribes of the Iroquois Confederacy. I live in Oneida County, the home of the great Oneida Indian Nation. The Oneidas and the United States have been friends for as long as we have been a nation. During the Revolution, they chose to split with their Iroquois brothers and support the American cause over the British. They shed their blood alongside their American allies all throughout the colonies. One such battle, right in Oneida County, was the Battle of Oriskany, one of the bloodiest of the Revolution. The years after the Revolution were not easy on the Oneidas. However, their strong will and determination enabled them to persevere. Today, the Oneidas have almost single-handedly transformed parts of my county from rural farmland to a thriving, nationally renowned entertainment hub known as the Turning Stone Casino and Resort. The establishment has provided much-needed jobs for nearly 5,000 individuals who were in need of work due to a downturn in our local economy. For these and many other reasons, it truly pains me to see tribes like the Oneida Nation and Cayuga and New York State and our local governments unable to resolve land and tax issues which have remained unresolved for over 30 years. I am here today to ask this committee to address the inconsistencies which exist with the land into trust process. The issue has alienated family members, separated friends, put neighbors at odds, and worst of all, divided our community. Now, at first appearance, this may seem like an easy issue to resolve, but please understand, this is not. Issues such as adverse taking of land into trust, lack of recognized limits on the amount of land taken into trust, collection of local and state sales tax, which puts local merchants at a disadvantage, loss of local school district property taxes, maintenance of local roads and bridges, checkerboarding of trust parcels, state and local regulatory enforcement, and the list goes on. The federal trust process is laid out in Title 25, Part 151 of the Code of Federal Regulations, allows land to be taken into trust status for a tribe under 3 scenarios, including when the Secretary determines that the acquisition of land is necessary to facilitate tribal self-determination, economic development, and Indian housing. There is no question in my mind that tribes need and are entitled to a fair and reasonable amount of sovereign land on which to conduct their affairs. More importantly, it is not only their right, it is important and some might say critical to their heritage. However, the current process does not adequately balance tribal self-determination with the potential impact on local communities. The regulations require the Secretary to consider, among other things, the need of the tribe for additional land, the impact on state and its political subdivisions resulting from the removal of the land from the tax rolls, and jurisdictional problems and potential conflicts of land use which may arise. In addition, the National Environmental Policy Act requires Interior to prepare an environmental impact statement in connection with any land into trust application. But Interior only evaluates the environmental impact associated with the Secretary taking title to the land, not the potential consequences of that action, in our case, to local municipal governments and to the school districts. The Caraseri case grew out of just such an unanswered question when the town of Charleston in the state of Rhode Island sought to require the Narragansett tribe to obtain building permits for approval for a sewage system. When Interior maintains that future development, municipal services agreements, and tax enforcement over transactions involving non-Indians are all issues ancillary to the trust decision, they remain serious issues that are unresolved by current federal trust process. I fully understand that these issues raise very serious and wide-ranging questions that are not easily resolved. However, government-to-government relations between the United States and sovereign Native American tribes necessitate that state and local governments also receive the assistance of the federal government for the protection of certain of their regulatory interests. But this creates a scenario very close to a conflict of interest for the executive branch of the federal government that must also satisfy a fiduciary duty to the tribes. This paradox is inherent in the federal trust process as it currently exists, and the result is a process that simply is incapable of adequately addressing these issues. The federal government cannot continue to simply throw up its hands and insist that the tribes and local governments resolve these difficult and complex issues by themselves. As a member of the first negotiating committee 12 years ago, I can tell you that we have tried. I would submit that it is imperative that the Interior and the BIA become engaged in dialogue, or at least a cooperating partner in helping local communities and parties resolve and address the differences on these issues. Otherwise, issues like these will continue to tear communities like mine apart, not only in New York, in Oneida, Madison, Seneca, and Cayuga counties in my state, but across the country. I am encouraged that the committee is holding this hearing today to begin the discussion of whether and how to amend the Indian Reorganization Act. I respectfully submit that this discussion should be one that assesses whether the current process is still striking the correct balance in order to facilitate tribal self-determination, economic development, and Indian housing, and how the present policy affects densely settled and developed regions such as areas like upstate New York. Again, I thank you for the opportunity to address this committee, and I yield back the balance of my time.